Mr. August, go right ahead.
Thank you, Madam Chairwoman. I've been sitting in the Bell Room for quite a while, and unfortunately the acoustics in there are terrible, so I don't really know what has been said. I know some of it, but I beg your pardon if I'm being redundant by any of the remarks that have already been made. But there's three bills that I'd like to address this evening. First is 7199, and certainly Mr. Belair just testified about high-capacity magazines, and Mr. Valentine did as well. The question about what is a high-capacity magazine is much like the question about what is pornography. It's in the eye of the beholder, I guess. The problem I have is that anyone who owns, according to the bill, anyone who owns a device that holds more than 10 rounds would have 120 days to remove it from the state, sell it to a licensed firearms dealer, or surrender it to the police for destruction. If someone doesn't do that, they're subject to a penalty of up to 10 years in prison. The state of New York had imposed a 7-round magazine capacity, and they found that the rate of compliance was extremely low. I believe a previous witness may have testified. And so today, in New York, notwithstanding the original bill, you can have a magazine that exceeds 7 rounds, but you're not supposed to put any more than 7 in it. Whether or not a magazine is high capacity, again, depends on the state. Colorado, which is the site of several mass shootings, as you know, says 15 rounds is high. Anything over that is high capacity. In Connecticut, to be sure, the magazine capacity is 10 rounds. However, it should be noted that in Connecticut, after the Newtown massacre, there was a provision that those who already own so-called high-capacity magazines could keep them as long as they were registered with the state police. And in Connecticut, you can carry that firearm with let's call it a high-capacity magazine, as long as you do not load more than 10 rounds in it. As I already said, New York gave in on its 7-round, which is very, very extreme. The fact of the matter is that a person with a modest amount of training can change a magazine in about 2 seconds or less. So to simply say that this is some sort of a safety mechanism is a bit naive. Because if you have a 10-round magazine and you can change a couple of them, you're adding about 3 or 4 seconds to a mass shooting scenario, which is not really significant in that type of situation. The other thing that is questionable about turning in any property that you already own is there's no market for high-capacity magazines if this bill passes, and therefore you can't sell it to a licensed dealer. What's he going to do with it? And what is a licensed dealer to do with the inventory of high-capacity magazines that are already on his shelves? And there's no provision for fair compensation for the person turning in their private property. House Bill 7243, it seems that the point is that Rhode Island is an outlier. Rhode Island is an outlier in a lot of areas, and this is maybe one of them. But I think the impression that is given is that there's a bunch of wild-eyed people with concealed carry permits prowling around the hallways of schools waiting for a shooter to come in so they can have a gun battle with them. Nothing can be further than the truth. Last year, I believe, when this bill was introduced, the question was whether or not there were any incidents in a school shooting or even a shooting at a church or wherever where a concealed carry permit holder was involved. I don't believe there is any, because a concealed carry permit holder has gone through background checks and demonstrated proficiency with a firearm and other requirements. So I don't believe there is any. The issue that was brought up about retired police officers being allowed to carry firearms in schools is very interesting to me. Mr. Blair said, well, people shoot at a stationary target. It's not what you see in like a school shooting, for example. The fact of the matter is a retired police officer qualifies the same way a civilian does. They have to fire at what's called an Army L target at 25 yards and score more than 200 points. The same as a civilian. And I don't understand how anybody can say a police officer who's been off the job 5, 10, 15 years, who has not had any additional training, is any more qualified than a civilian who qualifies the same way the police officer did. The interesting part about this bill to me is that it refers to Rhode Island General Laws 1149-9, which means that fire marshals, corrections officers, investigators in the AG's office, auto theft investigators, railroad police, conservation officers, members of the military while on duty, security guards, and gate guards at National Guard facilities are all exempt under this bill. Does anybody here really believe that these people have had extensive training in an active shooter situation in a school? And let me tell you one more thing. This is a personal experience that I had. I was in a civilian police academy in North Kingstown, the first one they had. As part of that course, we participated in what's known as the FATS simulator, firearms simulator, that all municipal police officers go through. And that is a large screen, probably as large as that wall behind you, that has a computer simulation that's played out. And there's various scenarios, and they're really don't shoot or shoot scenarios. The one I happened to be involved in, one of them, I was a primary responding officer in a school shooting situation. And what I saw is the whole thing playing out on the screen, students running down the hall screaming, teachers running every which way, and a teacher on the screen came up and said, he's down there, he's got a kid in the classroom. So as you walk down the hallway, you're actually visualizing, the computer's visualizing what you're seeing. I came around the corner, and there, sure enough, was a perpetrator holding a young girl in front of him. And I tried to talk to this person. You can actually interact with it, and the person operating the computer can respond in various ways. This situation was getting very desperate, and the perpetrator's leg was exposed. So I took a shot and hit him right in the knee. And the computer simulation stopped. The instructor asked, why did you do that? And I explained what happened. I said, well, I thought it was going to get worse, so I decided to try to stop the action any way I could. A police officer in the room then said, I would have shot through the kid to get him. And you could have heard a pin drop. And then he added, I'm going home to my wife and kids after the shift. So don't try to think that every police officer that responds to an active shooting situation is going in there with steely eyes and very well prepared to deal with a situation. That's a fiction. And many police officers will lay down their lives to protect the kids that are in that school. There's no question about it. But you cannot make an across-the-board ruling in that situation. The other question is on the two bills that deal with domestic violence. I think all of us are horrified by those kinds of situations. I think that it should be noted that right now the federal law that has been cited is being challenged or being appealed to the Supreme Court in Vozine versus the United States. That ruling has not been handed down, but it's probably interesting to note that Justice Thomas spoke from the bench for the first time when he asked a lawyer who was supporting the appeal or supporting a measure. He said, can you give me another area where a misdemeanor violation suspends a constitutional right? It's a pretty extreme situation, and I think the real question that has to be asked is whether or not in any of the cases in which a judge or magistrate has allowed a domestic abuser to keep their guns, has any of those situations resulted in a gun being used to kill the victim? That's the real question. And certainly there is discretion on the part of judges and magistrates, as was demonstrated by the 3 orders that were discussed by a previous person. The fact of the matter is that there's twice the statistic has, I think, been cited that it's 5 times more likely or 500% more lethal to have a gun in this situation. It's a little curious. I find that the statistic that has been cited is there's been 54 cases of domestic violence victims being killed in the last 10 years in Rhode Island. 19 of those have been with firearms, which means that it's nearly twice as likely to be killed. The person is twice as likely to be killed by some other weapon. Butcher knife in the drawer, baseball bat. We've had a killing with a baseball bat, clothesline, any other mannequin. But you're twice as likely in Rhode Island in the last 10 years to be killed by something else. Thank you.
Thank you. Any questions for Mr. August?